Assalamualaikum and good day. I be to Dr. Amira. My name is Amira Syakirah and I will be doing a video presentation on the case of Wong against PP. This case evolved around the principle of character evidence, whether the evidence falling within the scope of determination on one's motive should be deemed admissible in the court of law. Today's presentation shall be in three parts, mainly the details of the case, the reflection arising from the studying of the case, and the possible suggestions and recommendations to improve the framework covering the principle of bad character evidence. In this case, the appellant was charged for the murder of his own daughter. Prior to that, there was an incident where both of them were in the room alone in the same bed, as the appellant had asked the daughter to massage him. The mother had heard her daughter in pain, as well as saw her husband pulling up his pants getting up from the same bed. Later on, the appellant went out, bringing the daughter along with him, and insisted that his wife could not follow them. The daughter then went missing. 2 days later, the daughter was found dead in the well near the house. Fast forward to the trial, the evidence of an incident that happened 3 months ago was admitted as only circumstantial evidence were available for the murder. The evidence include the incident that the appellant insisted his wife could not follow them out of the house, as well as the complaint that was made to the village headman saying that if the appellant is found to have disturbed his daughter again, police report would be made against him. The appellant appealed as to the previous judgment. The issue in this case was whether the evidence of the incident which suggested an incestuous relationship between the appellant and his daughter amount to the evidence of bad character. The appeal was dismissed, hence the bad character evidence is admissible. The incestuous relationship between the daughter and the father was admissible by the virtue of Section 8 of Evidence Ordinance, where any fact relevant which shows or constitutes motive is regarded as relevant. By relying on only circumstantial evidence, a motive would help to secure the conviction. No discretion on part of the judge to exclude the bad character evidence. The ground of prejudicial effect of evidence was also denied by the court. The evidence was defined by the Section 55 of Evidence Act to mean the accused's reputation and disposition. The latter relates to the accused's inner qualities, trait, and integrity. In layman terms, reputation relates to what others think of him, while disposition associates with the question on your real character based on one's perception. The general rule is that the character of a party is not relevant in any civil or criminal matters. Only good character is relevant to be admissible in criminal proceedings. Generally, the evidence of bad character shall be deemed inadmissible, as stated in Section 54. This is in line with the phrase that character is not an issue, but the business of court is to try the case and not the man. Nevertheless, these are the circumstances where bad character may be admissible as evidence. Narrowing it down to this case, the exceptions under the bad character evidence being part of the evidence of motive, as well as the bad character being admissible under other provision of the Act, are applicable. In the said case, the appellant counsel relied on Section 54 of Evidence Act, in which the former stated that the evidence of indicating incestuous relationship between the deceased and appellant and a similar incident should be excluded, as it will give the rise of evidence of bad character. In my perspective, the contention made by the appellant held no weight in the attempt to apply the said principle of bad character. Referring to the previous statement, the admissibility of two incidents do paint the bad character onto the accused. However, one must focus within the scope of accused motive. It is well established that the similar incident 3 months before the death of the daughter, where the appellant insists that his wife could not follow them, as well as the evidence of the wife's report to the headman of the village, give rise of the understanding that the appellant had motive to continue having incestuous relationship with his daughter, to further commit the crime, and to prevent the possible importance of the deceased as a witness for the prosecution case towards the appellant. In reference to the probative value of admission of evidence, it is deemed to be a higher value compared to prejudicial value toward the appellant. By relying solely on circumstantial evidence, it should be a bigger reliance on it as a form of evidence indicating the motive rather than character of the appellant. The context of circumstantial evidence, which should refer to Section 8 of the Act, in which it stated that any fact will be relevant in order to constitute a motive for the fact in issue. Thus, the evidence adduced focuses on the motive of the appellant in the commission of the crime. In other words, it bears a higher evidential value than prejudicial effect against the accused. The evidence adduced in this case clearly shows that the arguments on it will fall within the scope of motive, thus give more reliance to the first proposition in relation to the bad character evidence. Section 54 of Evidence Act can be assumed as a shield for the appellant. However, it should be borne in mind that our Evidence Act still allows the application of other provisions in pending evidence, and Section 8 holds more weight compared to Section 54, whereby stated that no evidence indicating bad character of an accused shall be deemed admissible unless it falls within the exception laid down. Section 8 of the Act clearly indicates that the evidence, regardless of whether it falls within the scope of bad character evidence, shall be admissible if such evidence is relevant to constitute motive or preparation for commission of the act. The two incidents adduced by the prosecution give rise more to the possible motive of the appellant in the commission of the crime rather than the bad character evidence against the appellant. Furthermore, a reference to be made to the case of R against Paul, whereby the evidence of brothers and sisters' previous sexual intercourse was admitted to prove a separate charge of incest, in which it was deemed to be admissible. The evidence, if admissible in one ground, will not be rejected due to its inadmissibility on another ground. Thus, in applying the principle established in the case mentioned, I do not see any reasons to exclude the evidence on the basis of bad character against the appellant. As such, evidence holds further bearing toward the argument establishing motive of the accused. Thus, it is within my opinion that the judgment made by the learned court was right to dismiss the appeal against the appellant. In my humble opinion, the principle of bad character evidence remained relevant and pivotal in today's world. However, it should be borne in mind that there should be a further and intensive discussion made toward the applicability of the principle in the form of Section 8, whereby any evidence indicating one's motive should be admissible under the court of law. We may extend such scope to any evidence upon connected with one another that may form a whole commission of a crime, in which, if it give rise to the accused's bad character, the priority should be given to the public's interest rather than the accused's respect of the offence committed. The discretion of the court on the inclusion of bad character as other evidence should aid the prosecution's case in the sense that the evidence adduced may possess a higher evidential value, thus proving its importance in this proceeding. Motive, regardless of not being an element of a crime, especially for cases that only rely on circumstantial evidence to point the guilt of the accused, should be remain pivotal, whereby, by the virtue of Section 8, it can showcase that the real intent of the accused in the commission of the crime. Thus, it will allow the court to uphold the principle of justice and law. The framework of measuring the extent of probative value of evidence and prejudicial effect should no longer be a grey line, as probative value should supersede the prejudicial effect. The probative value should be given a more focus, as it could be considered as an important element to the case upholding the principle of fair justice. It is within my understanding that the legislation and judiciary should establish a concrete precedent and principle covering such area of law to avoid any form of misinterpretation of the principle and the miscarriage of justice resulting from an error of legal technicalities. That is all from me. Thank you.